Afternoon, everyone. Pleasure to be here. So my name's Aki. I'm from a law firm called Harneys. We're quite active in the fintech space. And so what I want to do, and to follow on from Harris's very good top-down approach of regulatory issues with ICOs and fintech issues, I'm going to try and do the opposite, which is a bottom-up, to look at the live cases as anonymously as possible that we have and that we've worked on in the last 2 to 3 years in fintech. So I think the first thing I wanted to do, can I, by a show of hands, can you let me know if you're a lawyer, an accountant, or a financial professional? Show of hands, please. Okay, thank you very much. Right, so ICOs, SCOs, DLT. So ICOs, everyone knows what that means. SCO, that's a term we've started to see in the last few months. I interpret it as security coin offering. It's also security token offerings, an STO. DLT, obviously, I believe everyone would know what that refers to. The bit that I like the best about the term DLT is the L, which stands for ledger. And it reminds me, as a lawyer, as we're always trying to categorize, what are these things from a legal perspective is, in many ways, a lot of the blockchain projects that we see are souped up databases of information. And so that helps us when we need to decide what sort of regulation applies to them. So I'll show you some examples of this in a moment. So as mentioned, I'm from Harneys. Harneys is an international law firm. We're based, I actually live in Cyprus. We have offices in other sunny locations, so we're very fortunate for that. That's me. So I'm the head of regulatory. I qualified in London, then lived in the BVI for a few years, and then since 2012 have been in Cyprus, and we, over the last 2 to 3 years, we've been involved in some pretty high-profile fintech projects from various of our offices. Okay, so first thing, setting the scene. So why do we care about all of this? So we care because fintech, we believe as a law firm that fintech has, despite all the problems with banks and regulators and this, that, and the other, fintech has come into the mainstream. 2017 was definitely the year of the ICO, and we think since, again, second half of 2018 to 2019, we see this potentially as the years of other DLT-inspired projects as well. So tokenization of interest is a game changer as well from a legal perspective, because we need to understand what are these things that are being issued, and that's what everyone's trying to grapple with. So there was discussion about jurisdiction, there was discussion about regulation, in some of the earlier talks about regulation potentially being lighter. At the end of the day, why do we care about legal issues? We care because the ICO project, the fintech project, whatever it is, will be judged against legal standards in the nation-state jurisdictions where the parties are based. And the parties could be the operators, the companies that are incorporated, the customers. So we have to always be thinking about these things. And of course, there are lots of legal ambiguities. It's simply not clear what some of these products are. And I think that was a point made very well by Harris. So regulatory overview. Impact of regulation. Again, why do we care? Well, we care because if we get it wrong, we could commit a criminal offense. So that's probably enough in its own right. We could breach licensing prohibitions. We could affect the scheme that we are trying to set up. The regulators could come in theory, and unwind all of the schemes and make certain contracts void. So this is why we care about all of this. Going back to basics then. So when an ICO or a fintech project comes on my desk, what do I do? How do I rationalize that with my lawyer's mindset against what I know of the regulations to be able to advise a client, is this legal or not? So I go through a checklist of things, which is also the sort of checklist of things that the regulators like ESMA, the European Banking Authority, the SEC, the CFTC in the US have gone through. And these are the kind of questions that I have in mind. Is what I have, are we dealing with money here? Are we dealing with electronic money? Are we dealing with shares? Are we dealing with debts? Are we dealing with derivatives? And so the common conception that an ICO is unregulated needs to always be challenged because it might not actually be correct. An ICO could come onto my desk that does something in a particularly different way that means actually the way that this particular ICO is operating means it does fall within some form of regulation. And one example of that would be, for example, if there is some sort of derivative, if the ICO product contains a future of some sort, so you don't get your token now, you pay now, but you get your token in a year's time. Potentially that could fall within futures or derivatives regulation, which is regulated under all traditional forms of regulation all over the world. So all those sorts of things to think about. So within Europe, the European Banking Authority takes a clustered approach to regulation. Again, we are just humble lawyers, so we have to try and look at the regimes that are out there. So we have the MiFID regime, we have the CRD regime, which governs the way that banks operate. The funds regime, payment services regime. These are all different regimes out there that are designed to capture bits of the market, the financial services market, and say that in order to do that, provide that service, in order to launch that product, you need a particular license. Now, the last one is the most prominent at the moment for ICOs and for fintech, which is the development under anti-money laundering rules in the European Union on virtual currency exchanges and custodian wallet, digital wallet providers. And that came in over the summer in 2018. So we have the first move towards real regulation in the European Union. So whereas in the past we could say ICOs are wholly unregulated, no one really knows, we already have a direction of travel there. And for example, in the UK, we expect the Financial Conduct Authority over there to issue some papers at the beginning of next year on this that may then lead to regulation coming out there, and then in due course, most likely in Europe as well. Okay, so cryptocurrencies. For me, cryptocurrencies, it always reminds me of something a law lecturer told me when I was still at university, that they're a little bit like the Holy Roman Empire, in that they're not holy, they're not Roman, and they're not an empire. Because with cryptocurrencies, we see, well, they're not really currencies. Okay, so that's the first thing we have to dismiss. Currencies would effectively mean that they have to be current, meaning they have to be accepted universally within a particular jurisdiction, so backed by a central bank. So they're not legal tender, they're not currency, they're not therefore money. So cryptocurrencies are not, legally speaking, money. Okay, so far so good. Right, now what I'm going to do is look at the views from the various regulators in the jurisdictions that we're based have taken to this. So, as I mentioned, because cryptocurrencies are not money, then a lot of the regulators take a very suspicious view as to whether a token that is issued has any intrinsic value or not. Now, the view from Cyprus is that the Ministry of Finance over there is quite keen on DLT products. Less so on ICOs. Same with the central bank. CySEC has developed something we call an innovation hub, which is a little bit like a sandbox. So they've created a safe space subject to certain regulations that entrepreneurs and innovators and technology providers can come into and create products which are compliant with the law. And as I mentioned, the fifth anti-money laundering directive as well, for the first time, defines what a virtual currency is. And I should just go quickly back. So what is the European view on this? Well, we say that it is a digital representation of value, not issued by a central bank. It's not universally accepted. It's not legal tender, but legal and natural persons that use it as a method of exchange. So that's the actual European definition of a cryptocurrency, virtual currency. As I mentioned, we have offices in other sunny locations. So those are the three principal offices: the British Virgin Islands in the Caribbean, Cayman Islands also in the Caribbean, and Bermuda in the North Atlantic. Now, in BVI and the Cayman Islands, the position is broadly the same in that they have not charged ahead as some other places. We heard about Malta and Gibraltar as well. So they haven't gone the Maltese route yet in this. They are sticking with the UK/EU position, which is that classic ICOs are unlikely to be regulated in their own right. But there are things that are going on. So we're looking at other parallel things like crowdfunding and again, sandboxing. It's broadly the same in the Cayman Islands. Bermuda has done gone a little bit different on this. They have actually, like Malta and Gibraltar, implemented a regime which has, to an extent, taken off, especially with US investors, and is seen as potentially quite popular there. So, in order to launch an ICO in Bermuda, you need a license from the Ministry of Finance. Okay, I don't think we have time for any case studies, but I will just, in that case, skip to one that I thought was an interesting one, because we need to understand what our clients are doing in a very holistic sense. So we had a client come through that wanted to create a system whereby it was effectively launching a token, and the idea behind the token was that it would swap from virtual currency into fiat or real currency, and then built within the system, there would be a swap somewhere else into another currency. And so it wasn't immediately apparent that that was the idea of the scheme. But then when we dug into it, we realized, well, actually, that swap, so VC to FC and immediate FC to VC, actually what we're doing there, we're basically acting like Western Union. And what we've done is replace the telephone with the blockchain. So all that's happening is a message is going in, cash is being converted into a token, token is then converted into another form of cash. That is a classic payment service. So that's the sort of situation where, although something might look like an ICO, some of the ways that it might behave might actually trigger regulation elsewhere. Okay, so concluding remarks. I fully agree with Harris. ICOs, this fintech, these are disruptors to the state of play in the financial services industry. The takeaway point that I'd like to make is that it's important not to take things at face level. It's important to do a micro review, understand what is this scheme, and I think that's important for lawyers, it's important for investors, it's important for everyone to really understand what is the purpose of this particular scheme. And although we might label something an ICO, it might have characteristics which go beyond the norm. The other thing, of course, is that we all live within nation states, whether we like it or not, and that's backed up by a system of armies, and there's simply no way of getting away from that. And each nation state has its legal system. So those legal systems must at all times be complied with. So I would urge caution, ensure that you are compliant, and if you have any questions, feel free to send me an email. Many thanks.